Morning, everyone. It's James from Community Legal Centres Queensland here. Happy Monday morning. What a great way to start the week, talking about risk management and practice changes in community legal centres. It is such an important part of our work, so thanks everyone for making the time to participate in this webinar. And thanks especially to our presenter, Rachel Neal, who I'll introduce in a few minutes. Can I begin the session by acknowledging the traditional owners of the lands from which we're meeting. There are lots of people tuning in from across Queensland, and in fact we've got a lot of principal lawyers from community legal centres across the country. So acknowledge that we all live and work on Aboriginal land and pay respects to Aboriginal and Torres Strait Islander people as the first custodians of this land, and acknowledge their continuing connection to the land. We're hoping to make a recording of this webinar available. We've also made emailed around a copy of Rachel's PowerPoints to everyone who was registered about an hour ago, but I see that there are some extra people who have joined us just in the last little while. So I'm just going to try and attach presentation to Queensland. What was your presentation called? CLCQ. That'll be a whole heap of CLCs. There we go. So people should also be able to download Rachel's PowerPoint from the handout section on your GoToWebinar control panel there. And a copy of it is available on our website as well. We emailed around the link a bit over an hour ago. There are a couple of ways that you can ask questions as we go through. You can type a question into the questions box on your GoToWebinar control panel, which we can then read and answer. The other way that you can ask a question is to press that button that looks like a hand. We'll see something that looks like a hand going up on our end. We'll be able to unmute your microphone and you'll be able to ask a question through your the phone connection or the your computer's microphone, whichever technology you're using there. It might be easier though to hold your questions over until the end of the presentation. Webinars aren't great for a kind of conversational, great kind of teaching and learning. So if you can hold them over till the end, that'd be great. If you've got burning questions, feel free to chip in. I think that's as much as I need to do by way of administration and housekeeping. So can I introduce Rachel Neal, who's a very experienced lawyer in community legal centres, currently the principal lawyer at Women's Legal Service in Brisbane. Also, though, our PII rep, and as all of you will know, the PII rep is one of the unrecognised champions in a lot of ways in making sure that CLCs are supported to provide excellent legal services and have a well-structured and well-managed legal practice. So Rach does amazing work, as do all members of the PII network around the country. And so it's great to have Rachel share with us some changes in the risk management guide, which was released a few months ago, and some other kind of key considerations that we should think about in the context of risk management and CLC practice. Thanks, Rach.
Thank you, James, for that, and good morning, everybody. I hope this isn't too dry for a Monday morning. We'll do our best to get through. It's probably about 35 to 40 minutes long. For people who went to the CLC Queensland conference back in, was that March? May. It's pretty much what was presented there, so you might not see much different. I'm going to be talking today about the second edition of the Risk Management Guide, so it's been amended. I would say up front that there's nothing major in it that is new that is going to affect your day-to-day practice. But I still think it's really important to have a look at what changes, what additions there are, and it's also a really good time for centres to revisit it and ask staff, volunteers and management committee members to read at least Chapter 2, which outlines and summarises the mandatory standards, and also so that there's an understanding of your own role within your centre and the role of your centre within the wider sector. So the Risk Management Guide second edition was published in May 2017. It's available on the NACLC website to all members now, and hard copies should have been distributed to all centres. If you find you don't have one, please contact NACLC and you'll get one sent out. So what's new in addition to? The biggest change, I think, and I'm going to spend a bit of time on this, is the change to class and the changes in terminology. While it's not strictly speaking a risk management issue, I do think it's worth revisiting it here because it is the major change to the RNG in terms of terminology. There's a list of things that we're going to deal with. I won't read through those. We'll go through those one by one as the PowerPoint goes on. So, change to from CLCs to class. This has obviously made changes, flow-on changes to the risk management guide, which I will refer to as the RNG. It's easier that way. So class, the terminology and the data field used in class is based on the terminology in the National Legal Assistance Data Standards Manual, which I'll refer to as the DSM. It's changed quite dramatically the way that we record the services that we provide. I'm going to go through those. So all work for centres falls under either services for individuals or services for the community. This is a table that is actually reproduced in the risk management guide. It's from the data standards manual, and it's a really handy snapshot of how the services for individuals and services for the community are broken up. And I'm going to go through each one because I think it's worth revisiting them. What we used to call casework, which would be divided into minor casework and then 5 to 20 hours, 20 hours plus, has now classified as either representation services or ongoing non-legal support services. And underneath representation services, it's broken down even further into 3 categories. So those categories of representation services are, number one, firstly, representation services is where you take on the carriage of a matter in an ongoing representative capacity. There's court tribunals, so it's ongoing representation in a court or a tribunal. It's basically where you go on the record and you see a client through that court process. It includes participating in any court-based or tribunal-based alternative dispute resolution, and it's important to remember that because there is a separate section for dispute resolution that is not that court-based ADR. And it's also important to remember that it doesn't include duty lawyer service. I'll talk a little bit about duty lawyer service. It's got its own separate category now, and it doesn't count where you giving assistance to self-represented parties. So the second term is dispute resolution, and that's basically helping someone at a lawyer-assisted mediation or some sort of resolution process, but one that falls outside of a court process. So maybe something at the family relationship centre doing family mediation. And the third one is other representation services. So it's where you are helping a client in an ongoing capacity, but you're not going to the court, or the matter doesn't proceed to a court, or that you're not required to appear before a court tribunal or inquiry. So I see this as a category where if you are helping a client to self-represent through a court process with different drafting of documents, giving advice on each stage of that court process, that would come under other representation. The other service for individuals is discrete assistance. So we're looking at the terminology is the provision of unbundled, discrete legal and non-legal services to service users. And it falls under 5 categories. So the first is information services. It's basically where you're giving information to a client that is of general application. It's not specific to their circumstances or their legal issue. And it doesn't include administrative tasks like booking appointments. It actually has to be providing that information to a client. Referrals is the second one, where you give a user contact details for another individual or an organisation that might be able to help them where you can't, or that might be able to help them in addition to what you can do. There's simple referral, which is giving them a phone number or a brochure, or a facilitated referral, which is a more in-depth process where you might write an email to a referral agency, giving them some background as to that client, obviously the client name, contact details, and the other party's details so they can do a conflict check, all done with the client's consent, of course, but that is a facilitated referral. Legal advice is what we used to consider legal advice, so it's fact-specific legal advice in response to a request to resolve their specific legal problem. You might have several legal advices, obviously intakes that you do. Sometimes those legal advices may become a file that you then call a representation service if you help that client in a path along their court proceedings, but that's a matter for each centre to work out when you decide to change it to a representation service. There is discrete non-legal support services. So that is where you've got counselling, general counselling, financial counselling, domestic violence support, Aboriginal and Torres Strait Islander community liaison. So anything that falls outside the realm of legal advice, and there's a one-off discrete support that comes within that category. And finally, there's legal task. And I would say that anecdotally and from speaking to other solicitors in other services, that legal task is probably one of the biggest headaches. And in terms of working out when something is a legal task, it's really a discrete piece of legal work, that isn't advice to assist a service user to resolve a problem. And the examples given, what might be preparation or assistance with drafting a document, writing a letter to another party, or advocating to a government department, say, to help them resolve their issue, but without taking that ongoing carriage of the matter. So a legal task will usually come out of a legal advice. You'll give your advice, they need something specific to be done, and a legal task can be done. And there may be more than one legal task that attaches to a legal advice. For centres everywhere, I think it's really important that we continue to talk about what matters fall within these categories. If there is, if centres are unsure about how to categorise certain work into the new terminology, there is a glossary in the RMG. It's actually within the body of the RMG now that summarises the terminology and gives a summary of that. If you're unsure, there is a more comprehensive treatment of that in the DSM. And the other thing that the DSM has that the Risk Management Guide doesn't have is information about counting and how you're going to count your legal tasks, advices, etc. And it gives examples too. So if you're unsure, go to the DSM directly and have a look at that. There's another separate service under Services for Individuals, which is duty lawyer services. So it's services provided by a duty lawyer at a court or tribunal. And it's all of the work that you do as that duty lawyer. So it'll be the advice that you give, the appearance that you make in court, and it also, and this has been confirmed by a number of other people I've spoken to about this, it also includes anything you might do, such as a letter, a follow-up letter. So that will be one duty lawyer service. If you help that same person at another duty lawyer date, then it's a second duty lawyer service. But if you're unclear about that, please look at the DSM and the counting rules for that. Another category under Services for Individuals is a facilitated resolution process. This is very different to dispute resolution. So this is where you're running the resolution process basically. It's not helping a client, it's actually running that. And so that was all services for the individual. If the other category under the class terminology is services for the community. And that's these four categories underneath here. So community education, law and legal service of reform, stakeholder engagement and CLE, and that's delivery of CLE, so CLE activities and CLE resources that you develop and send out to the community. So,
sorry, Rach, for interrupting. I know that the definitions for people has caused some confusion, and that people might have come up with specific examples where they have some confusion, or where they've come to a view about one of those forms or another. So this might be a good time to open up to questions. If anyone's got any questions or comments about how you're using those definitions in your practice, we probably can't speak to class and how you're entering into class, but conceptually how you're using those definitions to differentiate between the different types of services. So if you've got any comments or questions, please type them into the questions box there, or press that button that looks like a hand on your control panel, and we'll, yeah, we're just interested to know how people are handling it. I think for me, Rach, Amy probably flagged this, legal tasks is something that we're not really used to doing here. And that will play out particularly, I think, for services in their funding agreements where they base their estimate of the services that they will deliver on the previous understanding of the proportion of advices to cases that they were providing, without necessarily thinking through how many would get carved out from both of those categories into this new kind of middle ground that is legal task stuff. Yeah, and I think that's where most of the concerns coming from is, well, we've got these targets to meet, and how do we fit out what we're actually doing into those? And I absolutely agree that there needs to be an ongoing dialogue. You know, James and I may not have the answer to your questions today, but it's important that we know what issues are coming up for other centres. I think this isn't just confusion amongst CLCs or services. I think our funders and policymakers and state program managers around the country too are trying to come to terms with this brave new world and what it might mean. So it looks like a couple of hands have gone up and come back down. I don't know that anyone's prepared to go on the record with that kind of stuff. If you'd like to email through some of those comments afterwards, I'm really keen to get your take on how some of those definitions are going. A couple of detailed suggestions here. Good for CLCs. It's a good point. It would be good for CLCs Queensland to model some examples in the newsletters. So if you've got some of those examples, send them through to us, because I agree. I think it would be a good thing, and we might send some of those out through our digests as some of those tricky things that people are identifying. We previously counted services provided through a self-rep services other representation. Now that discrete task categories can be used, we're unclear as to whether we should continue to classify the work we do as other representation or discrete legal advice and tasks. Would appreciate any thoughts you may have. So self-rep, which isn't really duty lawyer services, but those kind of self-rep services in court and tribunal buildings, Rachel, where do you think they fit in this new? I think it depends to what extent you're helping that client. So if somebody comes in and they say, I'm in court on Monday, I need to file this form or an affidavit, and you help them in one appointment to do that, and you don't talk to them about any ongoing assistance with their matter or to help them self-represent, then that would be a task. It's discrete, it's a one-off. But if a client comes in and look, I'm going to take a very family law-centric, approach to this, because that's pretty much all I know. If somebody came to me, they're incredibly vulnerable. There's no way that they can that they're not going to have the capacity to prepare documents through that court process, which, as we know, can be lengthy. That's when you make the decision. In the olden days, it would be, okay, I'm going to open a file for you. But now I think the decision would be made that you will open a file and you call it a representation service. It also might come about if several of those discrete pieces of work and legal tasks are done. If the client continues to come back, it may get to the stage where it becomes clear that that client is going to need help every step of the way. And I'm not sure, to be honest, how that is dealt with, whether the tasks then become a representation service. Somebody did raise that at the presentation I did at the conference, and whether there's the capacity in class to change it over. That is something that I can take on notice and get back to everyone about. But that's another circumstance I can see when it would be representation service rather than discrete legal advice. Some comments coming through that there is capacity to change things in class, but I think sometimes that goes to conceptually what the definition is and when we should make those changes. Yeah. So again, that might be something that we'll take on notice, how, when things might tip over and when centres are suggesting that they tip over from one service type to another. Thanks very much. I was sorry to interrupt, Rachel, but I think that's a really good conversation to have. Agree. The main struggle, another comment that's got questions come through. The main struggle we're having is when you should have a client agreement for a legal task. Okay, so ordinarily we need to confirm instructions in writing or otherwise have some kind of written retainer. If we're providing assistance through a legal task, is there a need from a risk management perspective for some form of written retainer? Interested in other people's thoughts about that before I ask Rachel to answer, because I think it would be it would depend on the types of services that you're offering through the legal task, because the legal task could encompass so many different things. I don't know that it would be a hard and fast rule that when you're doing a legal task you need a written retainer, but there will probably be situations where you do.
Yeah, there may be, and it's probably a case-by-case basis. But if you're say calling a government department for the client, then it would be really onerous to have a client agreement for that.
Yeah.
You'd write down, obviously, that clients instructed me and given me consent to do that. But I would be very interested to hear what other people say about that. My gut instinct, I think, is that you would have your client retainer when you've opened a file as part of your file management, and you're providing that some, representation service rather than discrete task. But I'd be interested to hear other people's views on that.
The only view that we've had come in so far, thank you, Bill from Townsville, is a no. I think with about 15 O's on the end of it, they're saying it would be far too onerous. I think generally speaking that's right, but potentially there are some situations where it might need to be considered.
I would think that if it got to the stage where you felt, well, this is a big enough piece of work to need a retainer letter or a client agreement, then you'd want to err on the side of calling that a representation service and opening up a file. Because if it's a big piece of work, you need all of that infrastructure of the file management rules in the R&G to help you give that client the best service. That would be my take on it, and it's all risk management. There's no one answer to anything. I'm always interested to hear and take on other people's opinions on stuff like that. Okay, so I think we'll move on to the next part, which is the actual changes to the R&G. Obviously, all of those terminology changes are reflected in the R&G. That was the biggest change that happened. Is there any questions that we want to talk about now? No, okay. Like I said, no major changes, nothing to be overly concerned about. I'm just going through it sort of from start to end. So 3.5, stakeholders and roles. In the first edition, there was a separate sections for stakeholders and an overview of roles. They've now been amalgamated, and there's a few additions and expansions on those roles. It's a really good idea to read through that. It covers the role of individuals, clients, solicitors, everyone working within a centre, the state and territory associations, NACLC, funding bodies, and it just gives a really good overview of how we all fit as individuals and centres into that overall scheme. And then in each role, obviously, we have to consider all issues of confidentiality, accountability, and any conflicts of interest. R&G 3.5, there is a slight change here about a time frame for notifying your state association and PII with a change of a responsible person and a change of nominated person or appointment of a new one. It used to be left open that you just had to let them know. It's now being changed to say that that's to be, the appointment is to be done in writing and it must be advised within 14 days of such change. It applies to responsible persons and nominated persons. This isn't a new thing, but I just thought this was a chance to raise an issue that does come up every now and then. You only need to appoint in writing a new responsible person if that RP is unable to fulfil the role for any significant period, and that's the terminology that's used. What is a significant period isn't defined, and it's going to depend on each centre, and will depend on the degree of delegation that the responsible person makes to nominated persons. But basically, if a responsible person goes on holiday for a week or a couple of weeks, it often will not be necessary to notify the state association and the PII rep of that change. as long as those duties that will may arise during the holiday period can be dealt with by a suitably qualified nominated person. You don't need to do that formal process of notification. Any longer than that, you know, might be an issue and you might need to do that. But if you've got any doubts about it, speak to your state or association's PII rep. You know, it may be that it's something you don't need to do and it's one thing off your list before you go on holidays. There's a new section in 3.7 on mergers and amalgamations, and this is in response to a little bit of a trend and a movement towards centres merging into big centres. It hasn't happened in Queensland, but it has happened in New South Wales and Victoria. So this addresses issues that arise with mergers and amalgamations. If you look at the footnotes to that, there's some really useful links to resources that Justice Connect, not-for-profit law information hub, have developed. So information on what sort of mergers and amalgamations are possible and what the ramifications are for those, and also some guidance as to how you actually do it. So it outlines key legal practices, requirements that need to be fulfilled. This is in the R&G. Things you have to think about, like insurance, membership of your state or territory association as the amalgamated or merged centre, consideration of how you're going to merge your data and how you're going to deal with any conflict of interest. And there's also a useful table that's been inserted there on dealing with those conflicts of interest that will be of interest even to people who are not thinking of merging or amalgamating. Making sure that the new entity demonstrates compliance with the risk management guide, looking at whether there's runoff cover for any entity that no longer exists after the merger, and then notifying your local legal practice board if that's necessary. A part of this is one centre closing, so there might be a situation where one centre closes or both centres close and they become a new one. So there's a new section to deal with issues that might arise with that. Things like dealing with open and closed files, closing files, archiving or destroying files, documents that need to be returned to the client. So it goes into detail about steps that you need to take in relation to any centre closure and merger. With open files, there's a note there that you need to, even if the centre is merging, you have to get consent from the client to refer to the new centre before you make that referral. And obviously, when that happens, all conflict checks have to be done before the new entity agrees to take the matter on. This is just basically a reiteration of what is in the 3.8, what to do with open files, trust monies, looking at with the new centre on indemnity issues to do with with the previous matters, and then PII runoff cover. So under the NACLC scheme, this PII runoff cover is provided free of charge as long as the scheme is in operation, but notice has to be given to NACLC to liaise with the insurer about that. Another small change in 4.4 is to do with the excess fund. So this is about, in 2002, the PII policy included an excess of $10,000, and because of that, NACLC established an excess fund in 2002 to assist centres to meet that cost if they needed to, if a claim was made against them. There was also a legal investigations cost fund that was established as well, and it became sort of clear that there was no need for those two funds to be there. So in 2016, they were actually amalgamated. 4.417 gives a detailed process and information that's required when applying to the excess fund. So if that is ever an issue for your centre, just go straight there and it will give you an overview, and of course speak to your PII rep and the broker if necessary. Just a little recap about confidentiality. Obviously, Rule 9 of the Australian Solicitors Conduct Rule says that we must not disclose client information outside a legal practice unless in specified circumstances. And it's a very important duty that we owe to our clients. The reason that I've raised that is because there's a whole new section in there in the R&G about confidentiality and cloud computing. So CLASS itself is a cloud-based data system, and a lot of centres are starting to use cloud-based or other internet systems and services to store data. And there are risks that come with this, risks such as breaching client confidentiality, privilege, privacy, losing data, security breaches, and outages. It's important to ensure that appropriate security and risk minimisation is put in place and taking all action to protect confidential information. The new sections of the RNG go through issues that you have to be aware of. I'm not going to go into those in depth today. I think it's a whole webinar by itself because it's a massive issue. But there are some really good resources there that I've got on the next page. I'll just go to that one. The QLS one, that first one, I actually found that to be a really good practical explanation of the issues. And it's a good overview of issues that arise. The other resources there are good as well, so it'd be a good idea to have a look at all of those. I'm just going back to the last slide. There's been raised here that there are serious considerations where you use cloud computing or another service that's located or permits data to be sent outside Australia. But just to let you know that all class data is actually stored in Australia, so it's not an issue for class data, but it may be an issue for any other cloud computing system. James is just checking for questions.
Looks good.
Okay. So that's cloud computing. I think that I've been talking to James about maybe getting some very clever IT person to come and talk at more length about that, because it's something that is beyond my capacity. So on to conflict checking in 8.7. There are some sections on conflict checking that have been expanded. This is one of them. It'd be a good idea to read through it. It doesn't put any extra obligations that you didn't know about beforehand, but it does expand on data collection and the information of timely data entry so that thorough conflict checking can be done. These sections here that I've got in the PowerPoint talk about reliability, so that you can do efficient conflict checking. Data needs to be accurate and complete, so full name, date of birth, any other spellings of names are all critical. And this was in the first edition, but it has been expanded. Also talked about whether there's any supplementary data that can be used to identify a client if possible. The timeliness is something that I think is worth revisiting for all centres, that it's mandatory that everything is recorded in class as soon as possible. And there's a recommendation that where your data system permits, and class does permit this, that you consider making temporary data entries for clients when they make an appointment to ensure that by the time they actually get to the appointment, which might be 2 weeks' time, the other party or another party who is in conflict hasn't contacted the centre and made an appointment as well, which will just lead to having to conflict two people out. So I do know that there is the ability in class to do, I guess, a truncated data entry without, all of the client details to get over that issue, and it's worth thinking about whether that's something that you should be putting in place if there is a period of time between making of appointments and actually seeing the client. There's an expansion on the section about archiving data in electronic form. You're going to need a client's consent before you destroy documents, even if they're being archived electronically. It talks about having a system that is reliable, and it also talks about having a document that records the electronic storage process, so maybe a policy that talks about how you're doing that. This is a new section 8.14.4 that there are some documents that have to be stored in original hard copy form, and in a safe and easily accessible location. So things like wills, title deeds, etc., etc. There wouldn't be that many CLCs, I imagine, who hold those sorts of documents, but it's important to keep that in mind. There's also some footnotes to those sections which have some information and further information about electronic archiving. So there's an expansion and an amendment to privacy law issues. So we need to remember that privacy laws exist at the federal and the state and territory level. You need to work out which laws apply to you and what steps need to be taken. There's a new, the first risk management guide, there was a draft privacy policy, but that's been expanded and it gives centres some different options for their privacy policy. So it's worth revisiting that and having a look at whether that, if you do have a privacy policy, whether it can help to expand and improve your privacy policy. Centres also need to be aware that there may be privacy obligations under funding agreements. And an example given here of the NPA says that centres must comply with the DSM, and Principle 5 of the DSM requires data to be collected, stored and disseminated in accordance with the Australian privacy principles. So if you're funded under the NPA, have a look at those Australian privacy principles and make sure that you're complying with those. So it's recommended that centres develop a privacy policy, and as I said, there's a sample policy that's been improved. And also just keep in mind that if you receive a request where compliance with the request might breach your privacy obligations, it's important to get assistance from a relevantly experienced legal advisor and or your PII representative. That just goes over the sorts of things that's in that privacy policy. It gives definitions, it explains how you collect your information, when personal information can be disclosed and who it can be disclosed to and who can access their information and correct it, as well as dealing with complaints around privacy issues. So have a look at that amended privacy policy. So the final thing I'm going to go through is issues of cross-checking and some additions to the cross-checking section. There's a new introduction, and that's written out there, and it just talks about the fact that cross-checking is critical to implementing the national scheme. It ensures and demonstrates that a centre is complying with the mandatory standards. A small change is that it now is expressly stated that participation in the annual cross-checks and satisfactory compliance is a mandatory standard, and each centre that wishes to be a full member of a state or territory association must participate in that annual cross-check. It's important that centres understand the purpose of cross-checks and engage wholeheartedly in the process. Cross-checks can be time-consuming, and I know that a lot of people groan about them every year, but they're very important, and they're an important way for centres to share information and to work in a collaborative way that hopefully improves the whole of sector legal practice. There's a new section about cross-border checking and different scenarios that might arise with cross-checks that have come up in the last few years, I guess. There are centres that have cross-border services. There are centres that have branch offices interstate over borders, and it sort of gives some guidance in relation to that. So where centres have offices or deliver services in more than one state or territory or have more than one responsible person, there'll be different requirements, and the first port of call is to look at these issues, but you would also want to be speaking to your PII rep about how that's to be done. If there is a centre that operates as more than one distinct legal practice under the one legal entity, there needs to be a separate full cross-check on each of those different entities and has to be signed by the responsible person for that respective legal practice. It doesn't refer to centres that are primarily in one state but do outreach services in another state or territory, or provide assistance to clients from that other state or territory. So you're really looking at, are there client files held in another centre or another branch? But again, talk to your PII representative if you're unsure. If it's a situation where you've got a head office and then there's a branch office, the substantial cross-check is done with the head office, and then branch office checks that are in the questionnaire, the cross-check questionnaire, can be done, even if those branch offices are interstate. This section is about membership of state or territory CLC associations. If a centre is a member of more than one, they have to comply with the membership rules for each of those associations, which includes attending all compulsory meetings and participating in the cross-check processes of that state and territory, which should be across the board, should be fairly consistent, but it's important to have that, to run that by your PII rep if there's any, if you're unsure of how that should be done. And finally, where a branch office check is to be carried out by a different cross-checker than the person who did the full head office cross-check, which is maybe likely to happen where you've got a branch office in another state, it's important that those two cross-checkers talk to each other before and after the cross-check's carried out, so that there's consistency in the process of the cross-check as well as any reporting that happens afterwards. So nearly done. Finally, there's a few additional resources that are worth looking at. On page 59, there's a notification process flowchart, which if you need to notify is a really good first port of call. It shows you what you do and when you do it. It's worth looking at that. I couldn't actually duplicate that for this slide, I'm afraid. So we've also got an Appendix C, which is your notification form. Important to use that because it has the new broker details. We have a new broker and any notifications need to be sent to the new broker. You should be speaking about a notification to your PII rep anyway, and your PII rep will remind you of that, but just keep that in mind. Appendix D is the updated cross-check questionnaire, which takes into account the new terminology. Appendix E is a new document that's been formulated about PII representatives, their roles and responsibilities. It's intended as a how-to guide for new PII reps, but it's there for anyone to look at if you're interested in what PII representatives do. Appendix H, as I said, is an updated sample privacy policy, and we've got a new Appendix K, which is a sample information barrier policy. Now, there's issues that are going to come out of the changes to class and data standards, and some of these issues might raise questions that are relevant to the RMG, and because of this, it's intended that the National Network will do a further review late in 2017 to have a look at those questions or issues that arise. And it's really important that we get input from the sector about that. So please raise any issues that you come across with your state or territory PII representative. The RMG is a document that can continue to be amended, and it's important that it's done in response to issues that arise in the sector. Okay, so questions?
I'm sure there'll be plenty. So a reminder, folks, you can ask questions by pressing that button that looks like a hand, and we'll see a hand go up at our end, or you can type a question into the questions box. Judy, you put up your hand. Did you have something you wanted to ask? No, nothing from Judy there.
If anyone has any questions that you don't want to raise in this forum, then I'm really happy for you to either call me or send through an email. I can call and chat. I mean, It's always the case for the PII rep. You should be contacting your PII rep if you've got any issues, just to run things by them. Sometimes risk management got issues come up and you just need someone to soundboard. Please contact me if you need any help with anything.
Let's try. We'll email around some information about the webinar today, which will include Rachel's contact details. So there's a couple of queries coming around there. I might just see again, Judy, did you have a question? Your hand's up there. Just unmuted your microphone. No. All right. Can I, on behalf of people clapping and cheering at computers across the state, thank Rachel for that overview. It's such an incredibly important part of how CLCs organise ourselves to make sure that our legal practices do minimise their risks and are providing great services. So thanks, Rachel, not only for the presentation, but for the huge amount of work that you do as our PII rep in a whole heap of ways that no one really sees. We are pretty keen on putting a bit more support around Rachel and establishing a PI network or a PI subcommittee here in Queensland. So for those of you who have tuned in, if you've got an interest in getting a little bit more involved and helping the sector across Queensland as they roll out or as they comply with the risk management guide and think about those tricky legal practice questions, please reach out to either Rachel or me. I'll just finish. We have had one question come through from an organisation thinking about going paperless. Do we know of any centres in Queensland who have done that already? I don't think there's anyone on my radar yet, Rach.
No, I think there's been some inquiries about that, but that is an interesting question, and I mean, that might be another piece of work that needs to be done. It doesn't necessarily need to be with the R&G, but as a policy issue, perhaps if that does become more common, you know, we could talk about that, James.
Hooray.
Something happening.
Yeah. All right, thanks everyone for tuning in. Have a great
you.
week, and we'll speak to you soon.
Bye. Okay.